because we are running out of time. And we request Chief Magistrate to try and present within 15 minutes if possible.
Thank you, Rose. Good morning again. Now, I'm sure I want to be given 15 minutes. And when Mr. Canet asked me to prepare this paper, he had asked me to do a paper for 1.5 hours, which I duly complied with. Puts me in a very awkward situation, but I know you will understand. Some of the issues I was asked to talk about were in relation to warrants of arrest, warrants of attachment, taxation of bills, and application for police assistance. I've been sitting here and I've heard Josiah talk about the practice of an open auction. And he has covered almost everything that I prepared in that area. For that, I'm very grateful. He has taken my time, but he has also taken my work. I thank him for that. Briefly, when does attachment start and when does it end? I think the authorities we have now show that when you do the proclamation, attachment starts, and therefore those goods which have been you have proclaimed are shown to be attached to properties, isn't it? Yes. So we did not need to go to that, something which we already know. But I also know that you also know that the provisions of Section 44 of the Civil Procedure Act, what properties we can attach. That one we know, isn't it? Yeah. We know that we cannot attach clothes. Do we know that? Yes. Utensils. Yes. We know that. Yes. We know books of accounts. Right to sue in damages. Pension. Do we know that we cannot attach pension? Yes. Yeah? Yes. How many know? Let's now agree. Those are issues which cannot be attached. But the one I think which is most problematic is the one which talks about tools of trade and other implements necessary for persons, trade, or profession. I think that's where there is always some misunderstanding. And I may start, what are the tools of trade of an auctioneer? I mean, if your lawyer was asked to attach an auctioneer, what can he not attach? Somebody raise up his hand and tell us what the tools of trade of an auctioneer? Yes, but just stand up and tell us what you think of the tools of trade.
The reason being, there's a High Court ruling which says an auctioneer cannot attach a lawyer's computer. That's part of his trade.
Thank you very much. Thank you very much. What about a vehicle? A matatu? Is it a tool of trade or an asset? Why don't we get this very clear? Do we know why do we classify a matatu? Somebody has put a matatu, that's what he does every day. That is his business, that is his tools of trade. Is that a tool of trade or a jacket which we should attach? How many of us say that is a tool of trade? How many of us say that is attachment? Thank you very much. So, we also know that there are certain aspects of agricultural produce which you should not attach. I think you know that, so I think we don't need to go through that. But I want to say that we also know that warrants of attachment. That's where we can. This is purely administrative. We've had problems with auctioneers when they apply for warrants of attachment and they don't receive them in time. I don't know whether that's only in Nairobi or it's there in the country. I don't know country it's not a big problem because if you go there, you want your come for your warrant of attachment. In some occasions, even the magistrate adjourns the matters to serve you. And I'm happy for those magistrates because they understand that we are officers of the court and that time is of essence and they serve us very, very quickly. But that doesn't happen to be the man. I mean, it doesn't. I mean, I don't see when you can come for a warrant and get it on the same day. It is never. That's what I've heard. It takes more than a month. Why? Yes, I want to agree with you entirely that the Milimani from 6 to 10 is entirely corrupt. The only people who are not corrupt are the auctioneers. See, that's what they are doing. But I also noticed that sometimes we have unrealistic expectations, not based on the expected time frame. I know that even your own clients have sometimes unrealistic expectations of you. An advocate gives you instructions to get warrants from the money and proceed to attach and do whatever. And the copies, that letter, the client, isn't it? What happens? The next day, that client is in your house. Because he's wondering why you are not attached. You think that is realistic? Why? Because he does not know the process. So what we have done, if you notice it, we developed in June a document which gives the time frame on how your application is processed and how long it takes at every stage. And I want very, very quickly to run you through this. If you haven't seen it, how many of you have seen it? How many of you have seen that document which I authorized to be issued in June? To be specific, on 14th of June 2010. Then if you haven't, thank you very much if you have seen it. Because you read you go to the notice. If you haven't, then let's go to it. For execution of decrees, the time frame for preparation of the decree. Day 1, when you bring your documents, you go for payment of the decree received in the decree section. That's the day you upload it, isn't it? Day 2 and 3, serial number and drawing of the decree by the registry. Day 2 and 3, that's when the document is being prepared. Day 4, verification of receipts in the accounts. You know why? Last year, we discovered that most people have fake receipts in the money. Parallel receipts. They have given advocates who are, in fact, I put it upload until the auditors came and we checked the receipts which are in the file and they say these receipts did not come from the judiciary. We say, where did it come from? It looks like the judicial one. We said, no, this doesn't come. Because we have receipts which we get from our high court. And they are serial numbers. And the serial numbers, when we check, when you come, we give you the original. The duplicate is in the file, and the triplicate is in the booklet. So we said, no, that cannot be. And the matter has gone all the way up to execution. We said, let us give us that booklet which we made with. We checked, we found that the receipt which was paid, which the other person shows in page 73 20,075 was actually 75 shillings, which was so it sent us to start looking at it, and we did. And I wrote to the advocates who were concerned, and they came. They were surprised like one of us, because they gave their money for filing fees to their clerks who came, got some Wajiwadi within Milimani, or went to River Road and got receipts which appear like Milimani ones, and they went back and took out the money. And maybe a few corrupted our staff, they entered the receipts, and that is it. So I told them what I'm going to do, because we didn't pay fees in the first place, but I want to strike out this source. They said, no, wait a minute, let me bring the man who I gave the money. They said, really? We arrested 3, we took them to Kibera, the case is still pending. But it met as much later. So that's the reason why we have to check whether the receipts which we have in that particular file are genuine. And it takes 1 day, day 4. Day 5 is verification of the charge of execution, that everything is done correctly. Day 6, verification by the executive officer, and there all the fees and all the processes have been followed. Day 7 is stamping and allocation to the magistrate. Day 8 is signed by the magistrate. And day 9, you are ready to come for your degree. And on. It has taken 9 days for it to be ready. And I've explained where it goes to. What about warrants of attachment? Day 1, payment and receiving files at the execution. Day 2, giving serial numbers. Day 3 and 4, they are for typing. Because they have to be typed. You know that, isn't it? Yes. Day 5 is verification and stamping. Day 6 is for signature by the magistrate. And day 7, the documents are ready for collection. Marijuana? Yeah. Sorry? So what we are saying is that once if you have figured out the documents on day 1, please, if there are decrees, come on day 9. Don't come on day 4, day 5, day 6, day 7 every day you are coming, because it will not be ready. But if you come on day 9 and it's not ready, please let me know. Because we have committed ourselves to that timeline. That for Nairobi, I think that is something which we should be able to do and advise our clients immediately. Because what I also realized, sometimes when we didn't have these timelines, you will get the warrants when they are already expired, isn't it? We can't them by this date, and that's the time you are doing what? Then what have we done? We have also gone further and said, look, if you have your warrants which were issued, and they have expired before you have executed them, we have simplified the process, and I think that is supported by the amendments. And now you don't need to come. All you do is write to us and start asking for an extension, and then the magistrate will extend it for the period that he gives it. You don't need to be with us. That is something which will take a very, very, very short time. At least 1 day or 2 days. Let's come to the issue of police assistance. And this is where there is always an issue in the mind, and let me forget. I think Josiah has talked about it. We had a problem with these issues for some time back, particularly in Nairobi. We used to grant orders for breaking orders to auctioneers to go and break in and recover property and distress. On occasions, some of them went and did that. On occasions, they went and did more than what we had asked. We had occasions, very sadly, where somebody who was supposed to go and distress, but only went to distress, he chased the wrong person, he chased around the whole building now. Because there was only one person who was supposed to be distressed. He destroyed the whole building. We evicted the whole, all the tenants, and that was on Friday, and by Monday the whole building was done. Anyone who was asking said this is a court. But this is not what we had agreed. So certainly at some point we say no. Breaking orders are granted to you. Your powers to break in and retreat property is granted to you by statute. Why do you come to us again? But with the amendments now, you can come to us for police assistance. Because at that time there was no provision at all for you to come for police assistance in those cases. But now we do. It has also come with its own challenges. Its own challenges, because maybe we took a bit time to understand. What we say now is that if, for instance, you feel that there may be need for you to break in door or premises where both may be seized or can be possessed, that you may expect some resistance or intimidation by the debtor or another person, or it's likely that the breach of the peace is likely to result as a result of the seizure, repossession, or attempted seizure or repossession of any property you can, you can come by way of notice of motion to us and ask for police assistance. We have, in the money, developed a checklist for the documents that might be attached to the application. 1. A warrant of attachment and sent issued by the court. As we make this application, these are the documents we want to accompany that application. I do reserve reclamation notice. You have to indicate and annex your valid license issued by the National Licensing Board, copy, or letter of instruction, And where it involves distress for rent, you also have to include a tenancy or a lease agreement in cases of distress for rent. Eviction order issued by the court and directed about the auctioneer specifically. And you have noticed that on some occasions, I think in January or February, we'll address the warrants to the farm. I noticed that it's an error. At this time, we do address it to you personally, and then training and so on and so on. If it's in the repossession of our mortgage, a chattel, then you also have to annex an agreement of the all chattel's mortgage in the basis of repossession. And we also ask that if it's in the effect of a warrant of attachment and sale, that the same be made in the original file. And where you come for police assistance for all others, where we don't have a file, you come by way of the citizen's application, you work in a file that. We expect you in that application to state the order which you are prayed for, the reasons for the assistance, the supporting affidavit which enables you to annex all the documents which you have prepared. This has been a challenge. What I've done is that in the money we have a duty court every year, every week, which handles these matters on a daily basis. And we do the applications in the afternoon. And one thing I've noticed when I deal with them is that sometimes we come with applications which are incomplete. The documents are not complete. We don't have maybe the tenancy agreement, or the tenancy agreement where the application there is a difference. You come and say you want a police assistant to go and distress. Where? The defendant, the tenant's property. Where? Along Long Road. Where are you going? Long Road, you can see how the people category. So you just be specific which place. If it's a building in a building, please mention. If it is in respect of a particular property, mention. Because the police will not act. That's a big one. We also find sometimes you are so pressed by your client that you don't give, they also give you fake documents. Documents which they don't have. We find it difficult that you have accepted it. But we want you, this is your application by the way. And we want you to verify those documents because we are all going to hold you responsible. And the others who are actually out there. One of the diplomats told me, I want police assistance. He said, that's good. I look at the documents, why you want to execute it in some place along the way? Then who has instructed you? This one was instructed. Who are you going to distress? Whose goods are you going to distress? David S.K. Wade. Is it the David S.K. Wade I know who passed away? He says, I don't know. Yeah, I proclaimed the goods in that house, and I want to come, and I want the assistance. And I said, no. One of the advocates was there and said, and now, David S.K. Wade, unless there is somebody else. You see, as an officer of the court, that is something really. And I asked him, did you actually go to proclaim? And he said he did. But if he did, he should have known that those properties, or whoever proclaimed the person who deceased, we respect you when you are a person of integrity. And when you come like that, the next time we are now more cautious. The others who come, and I know this one, I'll agree and nitakupatia because I trust you. The others tunaanza hizi zake za ukora, waje tuanzie hapo. But as we have agreed previously, you are officers of the court and your duty is to be truthful and the people of integrity in the court. Now, the issue of police assistance, I think that reminds me of how I came and said, I got judgment. I said, that's fine, I can see you did. Again, it's true. Who are these are tenants? Yes, I said, that's fine. Who are the tenants? Together. So, what do you want? I want you to assist. What assistance do you need? Every auctioneer has refused. Who are the bid? I want you to assist me to work the bid. I said, that's fine. But that does not extend the court. And that reminds me the agony of the landlords. You know, somebody stays in your house, he doesn't pay rent, you tell him, no, now you go, I want you to pay me. He says, I don't have money. That's fine. Can you please get out with the money? I don't want that banner, that arrears, go. He said, I'm not going. When I was in Kusha, what they do is they get, when you are going to work, they come and get the doors and the door and the windows and the sun. And some irons, they go and when you come, there is the gentleman is very clear. I mean, a door is 1,000 shillings. 2 iron sheets is about 300 shillings. And this is a man who has refused to get out of the house. What do you do? Etc. But that is not what we advocate for. In Nyanza, if you want to get a new out of the house, he has refused. Go and kill a cat. Let's go as a body. Seize it and just move out. Taxation. We agree that the attachment starts and ends after proclamation, and the auctioneer is entitled to his cost. But what guides the cost and the cost which is charged? I want you to have a look at part 4, auctioneer's charges. Receipts of court warrants and letter of instructions, 1,000. That's your fees. Receipt of letter of court warrant or letter of instructions, 1,000. where no property is found to attach, or where the property found is worth 4,000 or less, do you know what you should charge? How much? 4,000. Fees before attachment or possession, 4,000. So that what I'm saying is that gives you your skills on how you should be able to attach. And I think somebody else asked yesterday, what happens to somebody where you attach for goods which are for 3 million? Was there a question like that? It shows to anything over 1 million shillings is 2%. Now, the issue comes, 2% of what? Of the value of the property you are supposed to attach? Is it of the declared amount? That is an issue which I really want. Some high court decisions show that you can even get the percentage of what you proclaim. If you proclaim goods for 1 million, you get that. Even if the declared amount was 100 million. But if you went and do a proclamation, you undervalued the goods, and now you come and claim 20% of what you did not proclaim, it becomes a bit. I think that's the area where we need to agree. So that if you are under charge like yesterday, with the bank class, that is illegal, isn't it? I think this gives us a guide on our costs and charges. If there is a dispute between you and the other on the issue of costs of your charges, then the same is the High Court can be taxed by the registrar. If it's the High Court, an application can be made, and that dispute is solved by the magistrate in the lower court. I was asked to speak for 15 minutes. I've taken longer than I was asked to do, but I want to thank you very much for what we have dealt with. Before I do so, we had agreed that we are officers of the court, and that we have a duty to us to do justice and assist the courts. But I want to mention that on occasions where we have gone and attached without instructions, high courts have made it a point that sometimes we have to pay those damages ourselves, or costs arising from there. Just wanted to read one ruling of the High Court talked about an auctioneer. I begin with the finding that the so-called auctioneer hearing violated each and every known rule within the Auctioneer Rules 1997. He was tried and found guilty by the Auctioneer's Board of having backdated proclamation, having issued defective proclamation with no valuation, attached the goods, or having overcharged goods from the complainant, the defendant applicant hearing, having used expired warrants, having failed to give the required 7 days notice of sale to the judgment debtor. It's of significance to point out at this stage that the warrants issued expired on 3rd of March 2003. The sale was advertised on 3rd of May 2003, and the actual sale was conducted on 5th of March 2003, the following Monday. Was that an officer of the court? But he had a license. I want to challenge you that make sure that you are not one of them. And I think with this exposure now we have, we are able to do honest business. So if we do that, we are able to be respected. This type of issue we receive in the judiciary, we are used to it. We ignored it, and finally, Kenya is on 4th of August. We agreed that we need to look at that fresh. And I should also bring yourself in that position where the whole country is talking about auctioneers. That's my request. If and when you come to remind, don't lead our staff into temptation. That woman came to me some time back and they said, look, I'm very annoyed. Why? So you sit down. Very annoyed. This Mulimani court, I don't know what's happening. I said, calm down. My file has disappeared. I said, oh, what is that? Let me call my client. So they looked for the file and they didn't get it. I was very unhappy. And I was apologizing profusely on behalf of my very corrupt staff. So I told him, look, what we can do, can we reconstruct the file so that you go to your office, photocopy all the documents, give it to us so that we can reconstruct the file and proceed from where it had reached. To execution. He said, my file also got stolen.
Thank you, Chief. And now we give him a better clap. That brings us to the end of the first session. And I want to point out that we are not taking questions. We will take questions later as we proceed with other sections because we have to go and take tea. Tea is ready. So if you might, please try very hard, take 10 minutes so that the next session begins at exactly 11:15. Thank you. 1 minute, 1 minute, 1 minute.
Morning, ladies and gentlemen. Something has been worrying me, and I've been receiving, as I talk to you, as I go around since yesterday. And today I've seen SMS going around